Shocking details emerge from a hearing in the case against two suspects accused of murdering a University of Wisconsin couple.
The court, unlike at a trial, must look at the evidence in the light most favorable to the state at this proceeding.
Dr. Beth Potter and her husband Robin Carey were found in a ditch near the campus arboretum. Both had been shot in the head execution style.
He was wearing a pair of boxers. That was it. She had been wearing pajamas and socks, but no shoes.
Detectives questioned the couple's adopted daughter, Miriam. Her story led them to zero in on her boyfriend, Kari Sanford, and his alleged partner in crime, Elijah LaRue.
Detective Burmeiser, during your contact with Ms. Potter Carey, did you and Detective Grand take custody of a cell phone that had been in her possession?
Yes, we did.
While detectives have evidence that appears to implicate all three in the couple's murder, only Sanford and LaRue are charged.
He overheard a conversation between Miriam Potter Carr and Kari Sanford.
Investigators uncovered a witness, a high school classmate who told police he overheard Miriam plotting with her boyfriend.
He stated that he had been in a ceramics class at West High School. They were talking about robbing her parents because they were rich and that they had bands of money.
But Sanford's lawyer tries to limit the damage.
When the victims in this case were discovered, to my understanding that Dr. Potter was still alive, is that correct?
Correct.
She was pronounced dead, my understanding is approximately an hour and a half after her discovery?
Correct.
During that period of time, she did not implicate Mr. Sanford in her attack. Is that accurate?
Correct.
While defense attorneys suggest there is no physical evidence tying their clients to the murders, cell phone records tell an incriminating story.
At approximately 10:57 p.m., where did the GPS data from Mr. LaRue's phone suggest he was located?
It plotted near the intersection of North Winkler Drive and Vilas Park Drive.
Could you describe for the court how that intersection would relate to the area approximately and where the bodies were found?
That would be basically the entrance of the UW Arboretum.
Just as cell phone tracking data puts LaRue at the crime scene the night before the bodies are discovered, surveillance video picks up this white van.
The victims had loaned their vehicle to Miriam Potter Carr and Kari Sanford for use while they were living at the Airbnb.
Defense attorneys take turns attacking the evidence.
We have no GPS suggestion that he was at any relevant locations.
There was zero evidence presented that he was the shooter of these victims. There was no evidence at all that he knew that there was going to be a shooting.
We have no evidence that ties him to the shell casings or any gun at all.
But there's enough evidence to convince the judge to let a jury make the ultimate decision.
This court does find that for both Mr. Sanford and Mr. LaRue, probable cause has been shown that a felony has been committed and that each defendant probably committed it as a party to a crime.
All right, probable cause is that first hurdle for prosecutors, but it's a long road from probable cause to proof beyond any and all reasonable doubt. That's the challenge that prosecutors have in each and every case, and I've seen it time and time again. Any case that you think, oh, they've got the guy, they've got the overwhelming proof, you got to get in the courtroom, and you've got to withstand the challenges, and you've got to convince 12 people beyond any and all reasonable doubt. Joining me tonight to talk about this, the attorney representing one of the defendants, Kari Sanford, is Jeremiah Meyer O'Day. Great to see you, Jeremiah. Thanks so much for joining us. We really do appreciate it. When you look at this case, what strikes you from the defense perspective? Like every case has something that is going to be either the theme or is the strength of the case or the weakness of the case. When you evaluate this, what strikes you about it?
Well, unfortunately, I'm not in a position to really get into all of that right at the moment. Where we're at right now is that some discovery has been provided, actually voluminous discovery, but we also know that many things are missing. And so I am not in a position to state publicly much of anything regarding my thoughts of the merits of the case.
So at this point, you don't even have all the evidence in your hands, so you can't even fully evaluate the strength of the case and what your approach is going to be here.
That's correct.
All right, so let's talk about this. Are you surprised that Miriam is not part of any charges here? Because what I heard in that preliminary hearing, it seems like, according to prosecutors, that she is somehow in the middle of all of this. Is that someone that perhaps you foresee as a potential witness in this case for either side?
Well, again, I don't have enough of the discovery to have a firm opinion on that subject. I do know that I have heard others expressing that's the same wonder that you are, other members of the public.
So as you approach a case like this, walk us through. You don't have to get into specifics, right? Because I understand you're limited. But what's the process for you? I mean, you've got an 18-year-old client. His life is in your hands. He may have taken someone else's life. A jury will determine that. So what's your approach, and is it any different because you have someone who is a youthful defendant?
The general approach is to get the evidence, get all of the discovery from the state, do whatever investigation I need to do to fill in the holes or to vet what the state has done. Very often the police settle on a suspect and cease investigating at that point. I've seen that in lots of cases. But it's in each case, you develop a theory and a theme of defense as you get the evidence. Because obviously everything has to come back to what's going to be presented in court.
Now, one of the things we've been covering and tracking a lot of cases around the country, some very high-profile cases, and one of the issues in many of them is whether or not the defendants, because you have more than one person charged, should be tried together or separately. Right now, in this case, it's separate trials, correct?
That is correct.
And is that something that is automatic? Is there an opportunity that prosecutors may attempt? Would they be permitted to attempt to join the cases at any point here?
Well, the law of joinder, it basically comes down to prejudice. The question always as to whether or not a given joinder of two defendants is proper for trial is whether or not having them have the same trial would prejudice one or the other of their defenses. And in this case, as an initial matter, the prosecution makes a decision whether or not to charge people in the same complaint or two separate complaints. And in this case, they decided to charge both co-defendants in the same complaint. And shortly, not very long after the prelim, a motion was brought that wasn't seriously contested by the state to sever the two cases. And that motion's been granted. At this point, I think it would be very, very difficult for the prosecution, if not impossible, to rejoin the two cases.
All right, so it looks like we're on track for two trials here. Is there, who makes the decision and makes the call on, okay, two defendants, which one goes first? And is there an advantage to going first versus second in a case like this?
I mean, there are advantages and drawbacks no matter which order you're in, and ultimately it's the judge's decision who goes first.
So as we continue to track this case, the other issue that has been, everywhere is shutdown of courtrooms and the potential threat of COVID, right, for everyone who's incarcerated. Has this been an issue at all for your client? And how is he holding up behind bars waiting for his day in court?
Our client is doing fine. It's Dane County. The Dane County Jail is doing what it can to limit the spread of COVID behind bars. I understand they've had some outbreaks, not quite as bad as what's going on in the prisons in Wisconsin presently. But as to my knowledge, he hasn't tested positive, and he's doing okay. He's 18 and he's been in a cage now for 7 months, and it's likely to continue on like that for some time. And so obviously there are stresses associated with that.
Absolutely. Jeremiah Meyer O'Day, we appreciate you joining us tonight. And I know and I understand and I appreciate your honesty in not being able to answer all the questions that I had, but I think our viewers understand that as well. They're very well versed in what takes place in these cases. Thanks so much. Appreciate it.
Thank you.